Join us in the fight to restore liberty and American exceptionalism. Together, let's make the case that our charters of freedom are worth defending and honoring. Right here is where the great American experiment comes alive. Let's get to work.
In this case, the affirmative argument will be beginning with Mr. Weisser for 4 minutes. And the question is, should the Constitution be viewed as a living, breathing document? Mr. Weisser.
I'm going to say that the Constitution was designed from its inception to be a living, breathing document. You can see in the Constitution, Article 5, the instructions on how to make changes to the Constitution. There's no point in putting that in there if you're not prepared for changes. People who designed the Constitution were aware that they were part of a long tradition of governance, going all the way back to Hammurabi's time and Babylonians, and they were trying to make something that was in keeping with their time in history. It was the Age of Enlightenment. There was a tremendous focus on the social contract of how to improve the society for everyone based on the rights of the individual. So, the Constitution was, as I said, is written to continue to adapt. You can look at the amendments themselves. The original 10 were added within the first 2 years of it being brought out. We've had 27 amendments since then, always trying to adapt to the situation of the time. We're not living in musket loaders and breaches anymore. We're living in a very 21st century society. And as our societies change, we have to realize the situations that are changing and have an understanding of the document that reflects the current society. For example, women. In the original Constitution, women had no rights. Black people were enslaved. Only about 8% of the population was even allowed to vote, according to state laws at the time. That's not the kind of society we want to maintain. I mean, as I said earlier, our history of America has been our efforts to live up to the ideals of our founders. And that's why we alter our document, our Constitution, as we get closer to the more perfect union that is in the preamble.
Thank you. Negative cross-examination.
The word no and the word shall not are mentioned 22 times, or at least a correlative, or no or shall not, 22 times in the Bill of Rights and 24 times in the 7 articles of the Constitution. If it's a living and breathing document, are you suggesting to us that the word no or the word shall not have somehow changed?
Not necessarily, but I am suggesting that the rights of, quote, other persons have. The original Constitution said other persons when they referred to black people. That has definitely changed. If you look at the Constitution, I have a copy here in one of my back pocket, you can see that there's all sorts of stuff that's been taken out. Because it wasn't right in the first place.
What does it talk about other people?
It talks about other people in Article 2, where we're talking about...
That's the exact...
Article 1, where we're talking about apportionment. And how people are, how the different states get their voting rights in the House. In the Senate, the state legislatures were picking their senators, but initially the representatives were based on population, and in particular 3/5 of the population.
Okay, very good. I want to clarify something. Mr. Weisser's putting words in my mouth when it comes to infringing on the rights of other individuals. I've never taken the position, never have taken the position, never will take the position that somebody can use their religious freedom to deprive individuals of their liberties. I've never taken that position, and I didn't take that position here tonight. In fact, I agreed with him that an individual could not sacrifice their children under the guise of religious freedom. I acknowledge that. And so there's no question that cannot be done. The living and breathing document, it is far from it. There's no such thing. I want you to imagine contacting your auto insurance claims agent following an accident, and here's what you hear. I truly am sorry, your coverage is based upon a living, breathing insurance policy. What you signed up for has evolved and changed. You're actually not insured as you thought you were. Nobody would sign up. Nobody would do this. We don't engage in these sort of contractual engagements. believing that they're living and breathing and they evolve with time. Nobody runs a business this way. This is just silliness. Our state laws, our federal laws don't allow for such silliness either. The idea is that an individual has a right to be put on notice as to what's forbidden, and why would we expect anything less when it comes to the U.S. Constitution? The U.S. Constitution is founded upon two immovable pillars, and those pillars are this: men and women are born free, and men and women with power cannot be trusted. If in fact that's the case, why would you put together a constitution that evolves with time, where the word no or the word shall not evolve with time? That is, the Constitution delegates power to certain individuals within government, but we, the individuals, we, the majority, can kind of allow an interpretation with time. That's no Constitution at all. You know what that's called? That's called the tyranny of the majority. That's what that's called, tyranny of the majority. And so why would we even have a constitution? Mr. Weisser brings up Article 5. Article 5 is the mechanism that can be used to amend the Constitution. Oddly enough, he emphatically makes my argument that it's not a living and breathing Constitution. If it were a living and breathing Constitution, why would there be a need for Article 5? There would be no need. Article 5 outlines a mechanism to allow for corrections, to allow for things to happen that were not considered at the time of the founding. But once there's an amendment to the Constitution, that amendment becomes like anything else in the Constitution: rigid. Rigid. That's what it becomes. The fact of the matter is that the word no, shall not, is found numerous times throughout our Constitution. And I think that we need to look back at people like Thomas Jefferson. It was Thomas Jefferson who said this: on every question of construction, let us carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed. That's what we're supposed to be doing. Not allowing this Constitution to become elastic, if you will. The idea was to put chains around individuals with power. In fact, it was Thomas Jefferson who said that as well. Speak no more, say no more of confidence in man, but bind him down with the chains of the Constitution. That's what you do when you're concerned about individuals with power. You bind them down with chains. And I believe what Mr. Weisser wants to do is make this a constitution where we bind people down with rubber bands. Allow them to do whatever it is that we want them to do. And so long as it accomplishes my agenda, I'm all about whatever it is that those individuals are doing. That was never the intent of our Constitution. It was never the intent. The Constitution is a written instrument, and its meaning does not alter. That which is meant when it was adopted, it means now. Thomas Jefferson said this: our peculiar security is in the possession of a written constitution. Let us not make it a blank paper by construction. The way that you make it a blank paper, the way you make it a piece of parchment, is distorting its meaning, to allowing us to move away from what the original intent was. And that was to bind people down, to keep government limited, because we know historically, when you keep government small, when you keep government limited, people are ultimately more free.
Thank you. Mr. Weisser, 1 minute for us to stand.
I was going to ask you about the Fourth Amendment. I was sitting here looking at it, and it says that we're secure in our persons, houses, papers, and effects, but that doesn't happen to mention my hard drive. So I'm wondering, what about my hard drive?
Well,
is my hard drive secure?
It is, because
it's not mentioned in there, though. That's not the original text, so it can't be protected.
That's absurd. The fact of the matter is, it doesn't mention many forms of speech. It doesn't mention symbolic speech in the First Amendment either. You have to go back to the original intent, Mr. Weisser. I think you're playing games with the Constitution and the text. The fact of the matter, hold on, I'm not done. The fact of the matter is, it says you're secure in your houses, persons, papers, and effects. If you understood the original intent, the idea of effects was personal property.
So our original intent, all these women are supposed to be servants, right?
No, that was never outlined in the original intent. Those were...
They certainly were prevented from getting rights. We talked to Ms. Adams and Mr. Adams about her battle to try to make sure that the women's rights were included in the original Constitution. They were not.
I'm going to, let me respond to that.
The original Constitution, women and black people don't have any rights. If that's what you really want to go with.
No, that's not what I'm going with. What I'm going with is, as I already outlined, Article 5. Article 5, it makes it emphatically clear that there are things that can be done. But I have to respond to this idea of blacks and women. The fact of the matter is, if you understood that the federal Constitution, that is the U.S. Constitution, applied to the federal government initially, and when you had individuals voting, that was a state function. And states were not performing in accordance to what the majority thought should happen, and so there was ultimately an amendment to the Constitution. That's why we have the 15th, and that's why we have the 19th. There was an amendment to the Constitution, and now the 15th and 19th Amendment are just as rigid as any part of the other Constitution.
Call on time here, gentlemen. Okay. Next, we're going to have the affirmative rebuttal by Mr. Weisser, 5 minutes.
Just pretty basically, we see that we're not living in 1787. We don't want a society that is bound to 1787 in some ways. I mean, obviously, beating your wife is still probably wrong, and treating people badly is still probably wrong. But there's all sorts of things that people used to get away with. I see these folks laughing up here. It used to be just absolutely fine to beat the crap out of your black guy because he was just a black guy. And that's enshrined in the initial Constitution. They knew that it was a problem, and they worked to change it. Everybody has an idea of what they'd like to be and a reality of what they are. And the Constitution was created by men who knew that it needed to be improved, and that's why they went through the great ordeal of putting in the Fifth Amendment. Mr. Krauser wants to talk as if the Fifth Amendment does not exist, as if all those amendments did not reflect a change of their contemporary society. You can look at what they call the Civil War amendments, 13, 14, and 15. Those are all related, directly related to the Civil War. One ends slavery, one establishes the rights of citizens, and one prevents you from prohibiting somebody from voting. You can look at the 16th Amendment. You can look at the 17th Amendment. These are all reflections of the society at the time. Built in that we could have that option. Look at the amendment that lowered the voting age from 21 to 18. Many of you people were 18 when that happened, or in that age range when we were sending boys off to Vietnam, and some women, before they were old enough to vote against it. And we realized that that wasn't the perfect union that the preamble was talking about, and that's why they made that change. Our Constitution is meant to be our document that helps provide the strength for our society throughout history. And if we stick to a previous piece of history, we won't be able to reflect the needs of today.
Okay, thank you. Negative rebuttal, Mr. Krauser.
Thank you. Mr. Weisser is arguing a mission statement. He's not arguing a constitution. Who would run their business based on a mission statement? You hope that certain things are accomplished. You hope that certain laws are abided by. And he's made my argument for me, to be quite frank. Article 5 emphatically illustrates that the Constitution is not a living and breathing Constitution. You look at the 15th Amendment that does not allow the prohibition on an individual to vote based on race. 19th Amendment based on gender. Is he suggesting that that is now somehow still living and breathing? Of course not. The amendment now exists, and it's just as rigid as the remainder of the Constitution as it now stands. That's the reality. And when we look at some things, I'm concerned that Mr. Weisser is just lacking in some fundamental misunderstandings. Fundamental misunderstandings about what the U.S. Constitution is designed to do. He talks about beating your wife, and he talks about treating people badly. The U.S. Constitution did not even give the federal government police powers. He's talking about things that are designed for the states to do. Those are for the states to decide. When you start talking about domestic violence and you start talking about robbery and rape and murder, those were traditionally state functions. So if we want to talk about state constitutions or state law, we can have that discussion. That's what we're talking about. We're talking about a federal government that has specific enumerated powers. In fact, it was in Federalist Paper number 45 that James Madison said, the powers of the federal government are few and defined. If you believe in the idea of a living, breathing Constitution, you have powers that are unlimited and undefined. I don't even know if he believes that, but I would imagine that he doesn't. And if he does, he emphasizes my argument even further. Think about the 10th Amendment. If this Constitution is a living, breathing document, why in the world would the states have jumped on board with this 10th Amendment? The 10th Amendment essentially says what? Those powers that haven't been given to the federal government are reserved to the states. Well, if the Constitution's a living, breathing document, they got fooled. They got taken. Because the Constitution can be enumerated and defined any way that those in power want to define it. The states no longer have power. It's that simple. The federal government can literally steal the power away from the people. Article 6 of the Constitution is the oath. It's the oath to uphold and support this Constitution. Those are the words in Article 6, to support this Constitution. Not a Constitution that you want to reinterpret in 2014. This Constitution as it's written. And if you don't like it, don't take the oath. Furthermore, impeachment. The Constitution gives power to impeach certain individuals in office. If in fact it's a living, breathing document, how in the world can you be impeached if in fact it's up to the individual interpretation of what exists in the Constitution? None of us wants a living and breathing Constitution. None of us wants to live in a democracy. We want to live in a constitutional republic where the rule of law is superior. And the way that you ensure that the rule of law is superior is by ensuring that the text, the black and white of that Constitution, is followed. And if you don't like it, amend it. But again, you amend it, you're bound by that rule once it's a part of the Constitution. Thank you.
Okay. That being said, we're going to take a 5-minute break before we go.